All right, folks, this is Sarah again with Parents Against Loss. This is a second video kind of following up to the first one that I did about a parent going into a child family team meeting. And this binder is a little bit more extensive because it is for the parent who represents themselves pro per in court. It's also for a family rights advocate to kind of help parents learn about their rights and how the process goes, the responsibilities of the department, the responsibilities of the parent, the rights on all parties, the children, the parents, that sort of thing when you work looking into a Department of Social Services custody case. This binder is not limited to what is in it. Of course, there's quite a bit more that could go in it, but I have a pretty good collection here, so I figure I'd share with you what is in this binder. You see a picture of my babies there. So here's the parents' parental aid for a CFT, Child Family Team Meeting. Now, I'm going to go through a little bit slowly so that way you can see what is in this particular binder. As you can see, it's a very big binder. Okay, so we have, this is generally the beginning to many of my binders. It's Chapter 7B, Juvenile Code, the purpose and definitions, which drives a lot of what is going on with Department of Social Services custody cases. The purpose of the statutes say is to provide procedures for the hearing of juvenile cases that assures fairness and equity and that protects the constitutional rights of juveniles and parents, to develop a disposition in each juvenile case that reflects consideration of the facts, the needs and limitations of the juvenile, and the strengths and weaknesses of the family. To provide for services for the protection of juveniles by means that respect both the right to family autonomy and the juvenile's need for safety, continuity, and permanence. And also talks about to provide standards for the removal when necessary of juveniles from their homes and for the return of juveniles to their homes, consistent with preventing the unnecessary or inappropriate separation of juveniles from their parents. So I got a little bit of the code in here. We have some administrative law, or administrative code rather, it's not law. This talks about when foster care is involved and there's funds involved, then there's responsibilities that are additionally added there. Excuse me. There's a responsibility for training your team members. So the local department in North Carolina of DSS has responsibility to train members according to the North Carolina Administrative Code. This is called the Strengthening Family Services Agreements in CPS Home Services, June 15th, 2017. It is put out by the North Carolina Division of Social Services, Jordan Institute for Families, UNCCH School of Social Work. That's a really good article. It was like a webinar service, really. It talks about family services agreements and that sort of thing, questions. It's good to have in here. Now, I want to talk to you a little bit about the Department of Social Services, your local department. You're going to find some things here in this binder that are like North Carolina Department of Social Services issued. And your local Department of Social Services is going to say, we don't have anything to do with them. And the state department is going to say, we don't have anything to do with the local services. But actually they do. Case law and practice in North Carolina says that, you see that right there. This comes from the Guardian Ad Litem Practice Manual. This is issued from the North Carolina Administrative Courts, who oversees the Guardian Ad Litem program. And it says here that there is a principal-agent relationship between the Department of Social Services, Health and Human Services, and your local services. So these guys, the big guys, the state is the supervisor over your local. Anything that you've seen here from the NCDSS, your local department is held accountable and responsible for. So you have case law that shows that. So don't let them tell you otherwise, okay? Okay, we have some child and family team meetings from your North Carolina Division of Social Services. And this talks about what the purpose is of it, what the definitions are, that sort of thing. Talks about facilitators. It's pretty good to have this in here. It's change number 03, 2016. Then here you have some online references to the very same things. What's assessment, what's in-home, foster care and adoption, using a facilitator, special considerations. You have practice notes for social workers. Some really good newsletters and things about practice notes. Here's some more things about holding the meetings. More practice notes. Okay, so next tab over. This is something that I printed offline. It's Child and Family Team Meeting Documentation Instrument for parents. Parents Against Loss does actually have one to use for parents that goes over a lot more than what they issue online for you. So these are, I believe, for social workers to fill out. I have a little bit of information in here about the differences between agreements and contracts. When you come up with a case plan inside your child and family team meeting, or sometimes the states will have, the counties in North Carolina will have a some sort of special meeting that's even previous to the, you do it even before the non-secure custody, which is, CFTs are supposed to be done before the non-secure custody because it provides reasonable efforts for the department to claim before they take your children. And some counties have a special demand in their local district rules for these meetings to definitely be held before the non-secure custody. But when I'm talking about agreements and contracts, as your case plan is an agreement. It says an agreement on it. You do not have to sign your case plan, but a case plan is required by federal law to be part of this case. As far as the social services goes, if you sign it, you are held accountable to it. That does mean if they change it or if they have errors on it or anything like that, you signed it. So if you sign it, you're signing an agreement with them. Now, it becomes a contract when it's enforceable by law. That's the difference between an agreement and a contract. Your agreement at some point in court, if you're in court, can be enforceable by a judge's order. The only way it's not going to be enforceable by a judge's order is if you have jurisdictional issues. Or, you didn't sign it. Obviously, it's not going to be, they can't push it on you, but the judge could if there's no jurisdictional issues like the UCCJEA, and you're at disposition. So up until a certain point, they really can't make you do what's in the case plan. But here's the thing, too. In a CFT meeting, you want the case plan to be very thorough. You want your federal laws covered. You want all your documents covered. You want everything covered because it's protecting you and your family from the Department of Social Services not doing their jobs. It's more of accountability, your way to hold them accountable. And also, if you're including your lawyer, if you have a lawyer, then this binder is going to really help you because these are the things that if you're picking out things that are important to you, you talk to your lawyer like FERPA. FERPA is a federal act that protects your right to see your child's educational records. Well, if your lawyer is supposed to be trained in this, social workers are supposed to be trained in this. It's required to have these training sessions and be updated about laws and stuff. So they're the ones who need to protect your interests and what you're bringing up for the benefit of your child or your children. So look into a little bit about contract law because it does apply here. They won't tell you that, but it does apply in these cases. So your case plan is your general thing that you're coming together in a CFT to create. And administrative code does address case law or case plans. That would be North Carolina Administrative Code, Title 10A, 70G.0504. Talks a little bit about, that code talks a little bit about the contents of the case plan, who can participate in the plan, and when case plans are required. Okay, we're going to go back to 10A NCAC 70A.0107, North Carolina Administrative Code. This is talking a little bit more about what is going to be in a case plan, what is required by state administrative code to be there. Okay, so we have two kinds of services for North Carolina Department of Social Services counties. We have an in-home service and an out-of-home service. I have a being ignored there. In-home service is not really supported by North Carolina DSS. It does not make the money. Assessments are not being done correctly, so children are being taken when they're not supposed to be taken. We don't really have very much money in our state for reunification or intensive in-home services. So I'm going to tell you that this binder is primarily composed of things that are going on in a CFT meeting that are for families that are out-of-home services needed or not needed because DSS messed up. So this section is going to be actually very tiny. And it's a shame that severe violations of rights for children and parents we have rampant severe violations in North Carolina where children are being removed from their homes when they do not need to be removed from their homes. We have a system to keep them in home and provide services. But that's not what's happening. It's not beneficial to the Department of Social Services. It's beneficial to a family where it applies, but not to the Department of Social Services. So all sorts of things come in there, like money, mostly money. But so this section is going to be kind of small. So we do have the NCDSS in-home services, outline here. We have the in-home family services agreement completion instructions. See, that's about all for the in-home services. Okay, so we're going to have a huge chunk on out-of-home family services agreement for children receiving family foster care services. I'll have to stop and add real quick. This is that code right there, North Carolina Administrative Code. Placement. The placement of children is often discussed in child-family team meetings. The placement is extremely important because not only does it have a lot of money surrounding the placement, it also has legality surrounding the placement of the children. Placement does have to be talked about at a CFT meeting. Here's a little bit of this administrative code is a little bit more about when Department of Social Services takes children and places them in foster care. So that's something that you might want to read over and learn about. Now here's the larger packet, the Out-of-Home Family Services Agreement. This you can find in the North Carolina Division of Social Services. This is the updated one that I have. You always want to look and see if your things are updated because they do quite frequently change them. And you want to have the year that your children were taken, the dates and stuff that are the changes that were made, because it applies. This applies to 2015. It wouldn't apply to 2014 cases or 2013 cases or that sort of thing. So you want to make sure you have what applies during your case and the updated stuff. This talks about good case planning using out-of-home family services agreements, focuses on problems which cause agency intervention, and establishes goals directed towards achieving safety and permanence of the child within a 12-month period. There are time frames for goals and meeting goals and completing case plans, and you'll find all that stuff in here. The Department of Social Services should never leave a case plan open-ended with no goals, no targets, no target dates to meet. They should never do that. There are very good practices for what is involved here. Now see, here's a draft that they're working on for the 2015 one. So I like to have the drafts in there too. This is the Out-of-Home Family Services Agreement Completion Instructions. Now all these things you can find online. This is a folder from the parents binder that you can take into a CFT meeting. So you have the in-home family services agreement. That would be DSS form 5239. You have the out-of-home family services agreement. That is DSS 5240 for forms. There's like a really good portal of information you can get online. Okay. So then your old case plans would go there. Laws and policies and procedures require your case plan to be updated whenever the parent wants it, when the parent requests it, and at certain intervals during the case. So if you have one case plan for the entire time you're in there, and you've never requested one, and it's been like maybe roughly 6 months, and you still haven't had an updated one, you have to update it. If you ever have to go to appeals court and you don't have updated case plans, you can't show your reasonable progress. There's just all that is to it. And appellate court will, for DSS, will be like, well, they didn't have reasonable progress. And you're like, yes, I did. I did all this work. Well, you have to have proof of showing that, and an updated case plan will show that. Just make sure that they're not going to be sneaky and add like a bunch of new junk on there, because that's the way they can keep your kids in DSS custody care for a long period of time. They just, keep adding stuff to your case plan. And if you keep signing, you continue to agree to it, and eventually they can terminate based on the fact that you have left your child in foster care for a year, or 6 months preceding a termination proceeding. They can do 6 months too, so they can do it at 6 months or a year. There's a worksheet that Parents Against Loss provides families in child and family team meetings. You want to look at federal law that talks about case plan. This in particular is Title 42, Public Health and Welfare. Talks about what should be in it. There's all sorts of information if you look into Title 42, if you're interested in what your state is compelled to follow by federal law. Okay, talks about, this is a little bit of case law I have in here in regards to being ordered to comply with a family services agreement. That's at disposition. Talks a little bit about reasonable progress, and that would be case In Re WG, filed 19th of July, 2011. So again, if you have UCCJEA issues, they cannot order you to comply with the case plan if they do not have jurisdiction. Something that the Department of Social Services likes to skip are federal laws. Federal law enactment. Now these things need to be thoroughly gone over in your CFT meeting so that you can assert your parental rights, your rights to be involved with your kids, their decisions. This is a little bit about the Americans with Disabilities Act that needs to be honored by DSS. There's a bunch of, this is Chapter 13 in what's called an abuse, neglect, dependency, and termination of parental rights proceeding in North Carolina. This Chapter 13 goes over federal laws relevant to juvenile proceedings. As you can see there, you can find that online. So you want to go over your federal rights protections, and those are all things that you can make complaints about, like FERPA, HIPAA, certain acts, UCCJEA. Those are all things that you want to make sure that you assert as a parent in your CFT meeting. That, hey, IEP meetings if you have children with special needs in education and stuff like that. I didn't want to go too much into parental rights papers in here, but it's really important. And so this is from parentalrights.org. Printed that back out in 2016. There's some landmark cases for parental rights. You really do need to know your parental rights going into a CFT, because they will walk all over you if you do not. So, okay, the rest of this binder gets into the components of a case plan and the discussions that you make in a CFT meeting. Something that should be discussed are visitations. Visitation should be discussed. It is required by law to have a visitation plan not only attached to your case plan, but presented to court before non-secure custody. Now, they always like to attach things to non-secure custody, not talk to you about visitation or anything like that. So if you get a chance to have a CFT meeting prior, you want to discuss your visitation in contact with your kids. If they take your kids and they do non-secure custody, they usually stick a sentence in there. You get a minimum hour visit supervised with your kids, blah, blah, blah. At a CFT meeting afterwards, say, hey, I don't agree with that plan. Tell your lawyer, hey, I don't agree with the plan. We need to make a plan. We need to protect my kids' rights to their family. That would be the autonomy of the family, mentioned in the state statute, 7B, the purpose, and get one of these plans going. See, this is an actual form that you can fill out, DSS 5242, Visitation Contact Plan. It's the kind of thing you want to put in front of a judge after you've discussed and worked it out with the Department of Social Services, or they're going to come back later and say, well, you barely had any visitation with your children. You don't have a bond there. We're just going to terminate. So make sure that you are standing up as a parent for your right for visitations. You want to look at state statutes 50-13.2. Also, Parents Against Loss is creating a massive booklet on visitations, which I will enter into this binder when it is all done. Talks about all sorts of things with visitations. Tweaking of custody orders are not allowed. This is why it's really important. This case law right here is why it's super, super important for you to have a CFT meeting prior to the seizure of your children. Because once you throw down a custody order, which is what a visitation order is, the courts generally in North Carolina do not like to change those custody orders. They want to have a super, super huge reason for you to change that. So make sure that you're really addressing custody and visitation, asserting your parental rights at the very beginning. You want to front load your case with your parental rights, so that way, as time goes by and they basically kill off your rights, you started out with a strong desire to really be a part of your child's life, and the fight's not so hard, because it gets real hard if you're trying to assert them after you learn them. This talks a little bit about opting out. Opting out is when you notify the public school that you're opting out of certain testing. It's something that you want to discuss with your social worker at the CFT meeting if possible. There's letters you can write for opting out. If your children are in public school, there's opt-out refusal. Now, a reminder, you can find all this stuff online. Here's some statutes about testing for North Carolina. You want to read that if you're an opt-out family. There's statutes about education of children with disabilities. You definitely want to thoroughly discuss the education of your children with the social workers. And anytime you're discussing these things and you want your social worker to know something, write it down. Write it down and get a copy of it. You never want to give your social workers anything without writing it down, getting a copy of it, because the social worker can come back and say, well, my cases are so big, I don't remember what they said. I don't remember what they wanted, what the parent requested. And then you also have proof to give to your lawyer or as a pro per parent that you were very involved with your requests for your kids and on behalf of your kids. There's rights to education in North Carolina for children's rights. They do have a right to education. A little bit about the No Child Left Behind Act. This is something that should be filled out in the CFT. It is a child education status component. DSS 5245. This helps North Carolina Best Interest Determination Form. This helps the social worker determine the best interest of the child as far as educational. DSS 5137. And there's the instructions for the determination form. A little bit about special education, procedural safeguards. You can find that online. This talks about religious exemption for health. You want to discuss the health of your children? There's a consent of parents or guardians for psychological services. DSS would ask you to fill that out to get your consent for things. They do need your consent for a lot of things. Child health status component. You're supposed to be informing whoever the children go to about the health of the children. Here's an authorization for treatment and medication. DSS Form 1812. Here's a health history form. DSS Form 5207. Form instructions. This has to do with the social worker's requests for adoption incentives. There's a verification of child's need for daily supervision. Here's a financial and medical plan. Funny that it says, when a child is placed in another state, the custodial DSS remains ultimately responsible for the financial and medical needs of the child and must retain jurisdiction over the child. This financial medical plan will remain in effect following the placement of the child and until a written termination from the receiving state in accordance with this particular state statute. So that just tells me that them placing children in foster care is better for the department, financially speaking, because then they can pin you as the parent for the financial and medical needs, the foster care maintenance. So, but if they take and place the children with grandma and grandpa in another state, Tennessee, for example, then the county doesn't necessarily make the money because the money they could because they're responsible for the financial and medical needs. So, just my personal opinion and thought on that matter, pursuant to this form, DSS 5221. All right. Each and every time you consider placement for a child, North Carolina Department of Social Services is supposed to do a family assessment of strengths and needs that is supposed to be attached to your case plan. This is an update of how your family grows and changes. If you do not have this, they're not properly assessing your family, and they're making opinions. They're not making assessments. And state statutes say that we are to go by assessments, not opinions. Here's how you kind of go over that form. Okay, I talk about child placement. That's huge for a CFT. You really need to talk about child placement in a CFT because if you are just letting your children stay in foster care and you're not actively, this is what I'm learning now, if you're not actively going ahead and trying to pursue them to get out of foster care, i.e. ICPC, which means child goes to another state, relative information, which means the child has a possibility of kinship care or guardianship, anything else aside from foster care, then gives the appeals court the ability to say, well, you don't, when they go to terminate your rights based on abandonment, for willfully letting your child stay in foster care, this is your responsibility. But they don't actually tell you that it's their responsibility to go ahead and go through the placement options. They're just okay with your kid sitting in foster care. So this is partially what they're supposed to be doing, but it's also partially what information you're supposed to be providing. And they're supposed to tell you that you're supposed to provide this information, but that they don't tell you. They don't tell you. So they basically set you up for a downfall. And your lawyers should be telling you this too. Lawyers should be telling you all of this stuff. They should be knowing these things. So it talks about, a safe and permanent home within 1 year. That's the goal. Here's a bit about placement decision making. And I'm going to read this because this part is really important. Really important for me to share with you. Okay? Placement of children, even in the best foster homes, causes emotional damage from their experience of grief, loss, anxiety, and or fear caused by separation from their families and their home. Children's experiences of home certainly include their experiences with their parents, but also include their experiences with siblings, friends, pets, house, neighborhood, culture, hiding places, school, play, favorite toys, chores, faith community, and so on. When children are removed from the home, they are removed from all these familiar things. Even if children have been living in a chaotic or violent environment, they may have developed skills to cope with that environment. Placing children in a different home that seems alien to them strips them of everything they know and everything that may have worked to help them survive. Therefore, removal shall not be considered until reasonable efforts are made to meet children's needs for safety and nurture in their own homes, unless no efforts are possible because children are at an imminent risk of harm. So these efforts are supposed to actually be prior to seizure in North Carolina, with the exception of imminent risk, which is supposed to be, there's a whole setup for determining imminent risk. Safety assessments determine imminent risk because they assess the safety. If the safety is too high, then you're at imminent risk, and then you take the child out. But if you don't have a safety assessment, you don't know, and you cannot properly document imminent risk. So it talks about risk assessments and all sorts of other things when you're deciding placement of children. We have very sloppy, supposedly professional practices of social workers taking children in North Carolina without reasonable efforts, stating that they've made reasonable efforts, but not actually what those efforts were. And you're actually supposed to attach to the petition, non-secure custody petition, the request for non-secure custody, the reasonable efforts that you made, not just the words reasonable efforts, but the actual efforts that you made. And these all would have been efforts. So you have the North Carolina Safety Assessment. Sometimes counties do have their own personal one, but it does comply with North Carolina DSS. So you want to consider that when you're looking at safeties. See, children have a right to their family, right? So this right is enacted and protected by Department of Social Services responsibility to seek out relatives and friends and family that be willing to take the children in placement. They do have tools to do this. They have forms they can fill out. At a CFT meeting is when they should be asking, or prior to seizure is when they should be asking, if you have another place for your children to go. These are letters that they would send to the family members and the friends, talking about visitation and custody and all sorts of other things. Federal law does protect the child's rights to extended family, but social workers are not helping the protection of the rights. Guardian ad litem are not protecting the rights. Guardian ad litem attorneys are not protecting the rights to children's rights to their family or parents' rights to their kids. This would be an initial provider assessment. It's what they do when they consider other people aside from the parents while the parents are working on their case plan. Talks a little bit about guardianship. Now, I want to tell you, in the best interest of the department, placement of the children starts, its best possible placement is foster care in its own state. That's the best possible placement. This is what's going to usually happen directly in the majority of the time. Best possible placement is in its own county. Next best is in the next county over. Next best would be with a licensed foster care family member in the next state over or in the state of. You're getting into lesser and lesser legality, lesser and lesser jurisdiction retention. Placing a child with the grandma and grandpa right away is in the best interest of the child, but not for the department. The child, that option does not grant the department any legality whatsoever. And they need the legality. They need jurisdiction over the kids. They need the money that's coming in. So guardianship, kinship, that wouldn't be as good as if you force the family members to take foster care licensing programs, because then the state could still get that money from the foster care incentives. but they do have the capacity for legal guardianship for the family members that have the children. Talks a little bit about American heritage, American Indian heritage. That has to be considered. The Indian Child Welfare Act has to be considered. And that doesn't mean if you're, I've been told in North Carolina, it doesn't necessarily mean you have to be enrolled with a tribe. If there's heritage there, Department of Social Services is obligated by the act to look into that. Not all of them will do. The ICPC is the Interstate Intercounty Services to Children. There's a whole bunch of stuff that goes on with that. You got checklists. You got, here's the Interstate Compact on the Placement of Children. The UNC has really good articles online. Parent Representation has really good articles online. Here's criteria for the family, North Carolina Administrative Code for foster parents. It's 10A NCA 70E.1104. This is actually what foster parents are bound to by the North Carolina Administrative Code. Here is State Statute 131D-10.1 is a Foster Care Children's Bill of Rights. They're actually supposed to be given their Bill of Rights and a certified copy from their social workers, and they're not. We're finding that they're not. DSS 5254 form, Youth Input Services Agreement. This gives your child the opportunity to say where they want to be. And a social worker doing this, or a guardian ad litem doing this, is actually conveying the child's wishes, not what does a child want from the store. That's not child's wishes. This is actual documentation of the child's wishes. So if you ask a social worker to fill that out for your children, it's actually documenting their actual wishes and not what the social worker is making up or thinking about. Or we want documentations. We don't want opinions. We have Transitional Living Plan for youth who are in foster care. When you're a certain age, you have to have that. That's actually a requirement by laws to have as part of the case plan when a child is so old. Agency Foster Parent Agreement. More criteria for the family. Mandatory criminal history check for foster parents. Foster home environmental conditions report. Fire inspection report for foster homes. Social workers' jobs are to visit these children in these homes, check on their statuses. So here's an initial visit for infants and children, youth in DSS custody. That would be Form DSS 5206. There's a monthly foster care contact record. All these come into play when you do a federal lawsuit and you demand copies of all the things that they have been involved with. Did you do your job? Did you do your job thoroughly? You had the tools. Did you utilize them? So this foster home request for waiver talks about changing placements and informing the parents. North Carolina DSS is supposed to inform the parents whenever a child's placement is changed. A lot of them do not do that. See, here's your foster care notification of placement form. And this is for children in the custody of North Carolina. Children have so many rights that are being violated by DSS, it's not even funny. So, if there's a critical incident reporting form. When incidents happen, they should be filling out these forms as well, and you should get those as well in discovery motions or whatnot. Here's a big thing that a lot of people don't understand or don't realize. North Carolina can terminate your parental rights based on no child support while child is in DSS custody, especially foster care homes. Okay? They are not going to sit down and tell you this, but they have the capacity in a CFT meeting to say, hey, look, your child's in our custody. We're going to demand child support. Okay? Statutes say that they can take that action because child's in custody. And if you say, no, they can't, I'm going to tell you, yes, they can. Look, foster care maintenance payments is what they're going to go after for child support. Okay? Because I guarantee you, they're going to want to get as much money as they can, maximize their profits. They'll take federal incentives, they'll take county money, they'll take grants and fundings, they'll take donations, and they'll pursue you for child support. The services that, if you agree to that case plan, you're agreeing to the services that you have to pay for and foster care maintenance payments. See? When possible, child support should be paid directly to the caregiver. It's in the NCDSS child placement papers. They're aware of it. Can't say that they're not. Foster care funding, how that works, they get money for taking your kids and putting them in foster care. Look, there's a voluntary support agreement. They could totally talk to you about this in the CFT meeting, but they often choose not to. I've not heard of a family yet that got the opportunity to realize that you could do voluntary support. They talk about payment for the social worker. I'm going to show you this. This is what I was saying, where they can't tell you that they didn't know about it. All right? INRI TDC, MDC, and TDC says, shortly thereafter, DSS and father entered into the case plan, to facilitate reunification. Down there at the bottom it says, and enter into a voluntary support agreement or pay child support as ordered. That case plan, or that case law, says that at the time that they were making this case plan for this father, they talked about voluntary child support. A voluntary child support agreement. All right? Department of Social Services has enough responsibility and knowledge to know that they can A, terminate your rights based on no child support, and B, that they could have talked to you about it at the very beginning when they made a case plan. So this is a very important subject to discuss when you're in a CFT meeting. All right. This is something that would be nice if the Department of Social Services would please issue to parents. Understanding Foster Care, Handbook for Parents. It is online. It'd be nice if you did that. Probably not going to do it, but it'd be nice if you did. And look, Understanding Foster Care, a handbook for youth. This helps kids understand their rights, understand what they're doing going into foster care. It'd be nice if social services gave that to the kids at the same time. And you have to realize that unless there's a domestic abuse case or like some sort of violence that would be perceived going on in a CFT meeting, that children are supposed to be involved in the CFT meeting. So that's the perfect time to give them all their rights, their information, that handbook. All right, this binder's getting a little tricksy. And here I have a really awesome article. It's called The 14th Amendment, Due Process Rights of Family Integrity, Applied to Custody Cases Involving Extended Family Members. It's a really good article by Kevin B. Frankel. Okay. Now, some cases, it may not be your case, but some cases do touch on domestic violence. There are assessments for forms for the subject of domestic violence. If there is domestic violence in your case, these things should be addressed. You'll find that Department of Social Services makes up domestic violence. So, I mean, if they're going to make up domestic violence, they need to have assessments that they're basing it off of, or really they're entering hearsay into court. And there's an actual case law that says that you have to give the court notice if you're entering hearsay. But they do have tools if there is domestic violence in the case as an element. Okay, I want to talk to you a little bit about responsible individuals list. That is a blacklist for parents in North Carolina. If you are if you're alleged to have what do they call it? Severe abuse, severe neglect, then you're more than likely going to go on the RIL, the Responsible Individuals List. That's State Statute 7B-320 is what you want to look into that. Like I said, that's a blacklist. That's a hearing itself. They're required to give you notice when they put you on that list. If they are behaving in your case like you're a criminal maniac and they're not putting you on that list, you can be like, hey, look, you don't even have me on the real list because I was late in showing up with my kid for school. That's another thing, too, is if you've never had CPS involvement and they're terminating your rights, you're like, well, why are you terminating my rights? I don't have this long history. I'm not on the real list. These procedures and policies were not done for my family. How did we get to this point? So this talks a little bit about the real list. And they're fully capable of telling you about that in the CFT meeting, that you might have that possibility. Because there are certain procedures that they have to go through in order to give you an opportunity to have a hearing to defend yourself in that. Because it's separate. It's a criminal hearing. It talks about a little bit about that. One thing I did not really put in here is about confidentiality, but you can study that for yourself if you'd like. There's a release of confidential information form. They can't just go up into the hospital and just gank your records if you have no physical abuse for your children, or gank your personal records because that violates HIPAA. They have to get consent for that. The only reason they don't have to get consent is if you physically have violated your children and they need immediate care, and on the non-secure custody petition they have marked that. You have to be careful on your non-secure custody petition because sometimes it will mark it and there's no physical abuse present. And then your lawyer has just waived your rights without noticing it or saying something, and to actually keep your rights to medical decisions for your children. So you gotta be careful of that. So part of the case plan that you're creating is concurrent planning. They have an initial plan and concurrent planning. It should always be reunification as the first part of your plan, but it's a really good article about that. And then this one's kind of a double whammy. It's outside of its block, but it's concurrent planning and making medical decisions. This was a webinar issued for social workers, February 11th, 2016. It's really super informative. I really liked reading it. It's really cool. So I would suggest looking into that. It's pretty good. So, and then last but not least, the smallest section that I have in this binder is reunification. Because it's the smallest amount of money that we get in the state for putting families back together. Families are required to have a reunification assessment prior to reunification. So if you're getting antsy about your kids coming home, say, hey, where's my reunification assessment? And there's instructions for that. That would be DSS form 5227. And that concludes the CFT binder. Now, this is not everything that could be in a CFT binder, obviously, because you could go deep into federal laws, like I said, FERPA, HIPAA, those sort of things. You could have more case law in here about case plans and concurrent planning. You could have all sorts of things in here. But this is what I consider a pretty thorough binder for a pro-per parent or a family rights advocate in North Carolina. And I hope you enjoyed this video. I know it's kind of boring just going through the binder, but some really good resources in here. Some good things to consider and think about when you're going to a child family team meeting, especially when you want these child and family team meetings prior to seizure. It negates all sorts of hassle and fight and adversarial relationships in court to do that. So there you go. Hope you guys enjoyed. I'll get more videos up when I get the rest of my binders kind of to a point where I like them. And I hope you've learned something today, and I hope this helps out some families in North Carolina.